Okay, good afternoon and welcome to the first speaker event of the second semester. And we're very fortunate to have with us today Natasha Affolder, who's an associate professor at the UBC Faculty of Law. She brings a very distinguished record of past studies and practice and writing and ongoing work. She completed her law degree at the University of Alberta and her PhD in law, or her doctorate in law, I should say, the DPhil at Oxford University, where she studied as a Rhodes Scholar. She practiced for a number of years in Boston, and she's been on faculty now for a number of years at UBC and has published very prominently in the international law field. And we're very fortunate to have her here today to talk on some themes related to international environmental law and some of her ongoing research in that area. So thank you for being here.
Thanks, Dwight, and thanks to the faculty here for the very warm welcome that I've had. And it's not just warm in the sense that I didn't come last week, but it's been very warm and generous, so thanks to you all. I'm talking today about global biodiversity. And typically when people start talks on global biodiversity, they have pictures of cute baby polar bear cubs, there's a few dolphins, and then customarily I start throwing some shocking statistics at you about how quickly the biodiversity is disappearing, how the species that you still hold dear won't be there for your grandchildren, and into about 5 minutes of my talk you are thoroughly depressed. So I'm not going to take that conventional way of opening my remarks because I think that many of you already know the statistics. If you're addicts of nature documentaries, you can certainly know more than I can ever tell you. But also I think it's not quite fair on a Monday to give you all that so early in the week. So what I want to do instead is to focus on an area of international biodiversity law where there is increasing excitement at the idea that maybe there is actually some potential around these innovations, and we'll look at that word later, to protect biodiversity. And the mechanism that has conservation scholars and biologists quite excited are something that we spend a lot of time talking about in law school, and this is the contract. So what I want to go through is a number of quite recent contracts or form of contracts that are being used for global biodiversity protection. These contracts largely have escaped the scrutiny of legal scholars. This isn't something that's in our environmental law textbooks, but it is something that's of interest to economists and conservation biologists. While their work takes on the form of legal documents, we're going to see the problems that emerge when you have those committed to saving biodiversity, taking an approach that law is just the technical handmaiden. You have the great ideas if you're an economist, and then you get a lawyer to paper up the deal. Law is, in other words, very much seen in an instrumental way by these agreements to date. It's what I call a sort of law as plumbing approach. Someone else does all the thinking, and then when the problem emerges, you call the lawyer to help you with your agreement. So that's just a little bit of an overview of where we're going in today's talk. The contracts take varied forms that I'm going to talk about. And I think because contracts as we know them are often one-off instruments, and even more so where they use different names and take different forms, it's easy to think that these are just obscure one-off agreements of interest to our global newspapers, but not a sort of more significant collective phenomenon. So I'm trying to establish in this work that there actually is a collective phenomenon here, a move towards contracting that requires a lot more thought from environmental lawyers. And so to suggest that such a collective phenomenon exists, I have given it a name. And the name I use in talking about these contracts is to frame them as transnational conservation contracts. And each of these words is intentional. I call them transnational because they clearly involve actors between jurisdictions, but they don't fit into the framework of international law as we know it. So international law still has quite a state-centric focus. International law looks largely at relations between states. The type of contracts I'm going to talk about are transnational in that they involve interactions between jurisdictions, but they are not restricted to state actors. In other words, local communities, indigenous peoples, sub-state entities, states, corporations, NGOs, these are the principal authors and architects. And so this is how I frame them as transnational. Now, transnational puts us really outside the comfort zone of a lot of legal intellectuals, because we still are very much trapped in thinking of law as either domestic law or international law. So this is a sort of murky ground, and I think it's one of the reasons why these agreements are obscured. The second label I give them is conservation agreements. And conservation is a very loaded social and political term. It has come, big C conservation has come to mean a practice of preserving pieces of wilderness or territory, very much with the idea that they should not be developed. So this contrasts with other environmental protection methods that might be seen from more of a sustainable use paradigm. But the agreements I'm going to talk about are very much do not touch, do not develop, very much conservation agreements. And the third term I use is that of contract. And contract, of course, comes to us as lawyers as a term that denotes a particular legalistic form of agreement. And so the agreements I'm going to talk about do not all satisfy our tests under Canadian law for a contract. But I think it's important to use this term because it denotes the need to inquire into the legality of these agreements. And this is something that largely hasn't happened because these agreements have not been on the radar of lawyers. So to give you a couple of examples of some of the manifestations of these agreements, and I won't go through this all, this is just to give you a few of the agreements that I'm going to talk about. So conservation concession agreements are very much like logging concessions or oil and gas concessions, except that the party buying the concession is a major conservation organization. To give you an example, Conservation International in 1992 went into Peru and said, we've got to do something about protecting the forest here, pristine, undeveloped forest, from logging. How can we get in and stop this logging action from happening? So one way they attempted to protect the forest was to purchase logging concessions. In other words, when a concession came open, Conservation International was there with all the other logging companies as a bidder, and it made sure it was the highest bidder. So it succeeded in getting this bid and then decided that it wouldn't cut the forest. It was going to bid and keep the forest intact. This became problematic because under Peru's forestry law, when you purchase a forest concession, you have to commit to a certain allowable annual cut, the same as Canadian law. And of course, they weren't going to do this. So the next step was to get some legal development organizations involved and help Peru reform its forestry law. And this happened. Peru changed its forestry law so that this sort of conservation purpose could be a legitimate purchase of a conservation, of a concession. Similar things happened with fishing, something called reverse fishing licenses. Major conservation organizations have gone in and bid against fishermen and purchased fishing licenses, again, with the commitment that they won't use them to catch fish. So that's what a concession agreement is. One of the most sort of exciting new forms of property and resultingly of conservation agreement concerns forest carbon. Since the Convention on Biological Diversity was signed, there's been increasing recognition that protecting forests from degradation and destruction is going to be a major contributor to protecting biodiversity, but also for reducing greenhouse gas emissions. So the goal of protecting forests has translated into forest carbon agreements. Generally, the purchasers are companies or nonprofits in the industrialized world. The sellers of the forest carbon are entities, often local communities in the developing world. And this has now been institutionalized through the mechanism called REDD+, or reducing emissions from deforestation and forest degradation. So there's an institutional mechanism for these agreements. Those of you who like to think about property can imagine the challenges of recognizing this new form of property that is necessary for markets in forest carbon to fully take place. And the agreements that I mentioned are not only between non-state actors. In this area of protecting forests, we've seen a lot of interstate action. So to give you an example, in 2002, Norway committed to pay Guyana $250 million over 6 years through a memorandum of agreement committing Guyana to protect its forest, the forest that was subject to the agreement, as heritage for humankind. So we're seeing these transnational flows of resources incorporated in legal agreements to try to affect some of these changes. And I'm not going to go through the whole list, but this gives you a bit of a flavor of the type of mechanisms that are being used. I want to say at the outset that this institutional architecture and even these individual agreements are not what I would frame as dangerous competition for international law. So if you're starting to feel anxious or worry that there will be no hope for international treaties, that states won't fly around the world engaging in decade-long treaty negotiations to solve environmental problems because now we can just sign contracts with each other, don't worry. This is not a competitor system for international environmental law. Rather, I see the rise of these forms of private authority deeply integrated into the international law system that we know it. Many of these agreements emerge out of commitments that various parties have made, for example, under the Kyoto Protocol or the Convention on Biological Diversity. The whole mechanism of access and benefit sharing agreements emerge out of the Nagoya Protocol that was recently signed, which really set up an institutional mechanism for these agreements to emerge. So I think that it's worth drawing attention to these agreements, but not in the way of framing them as a major potential threat to international treaties. I think there is a statement about international treaties that's being made here quite clearly, and that is that international treaties take too long, are too ineffective, and if we have to wait for the impossibility of domestic implementation of commitments that countries meet at the international stage, well, good luck if you're dealing with biodiversity. It will be gone by the time we get to domestic implementation of watered down lowest common denominator treaty commitments. So I think if you want to read anything into the emergence and proliferation of these contract-based, often private-based mechanisms, it's a real impatience with treaty mechanisms as we know and implement them today. So why do we know so little about this other stuff? I want to talk about and attempt to explain what I see as 3 reasons for the gaps in our knowledge about transnational conservation concessions. The first reason I see is the fact that these agreements have been largely framed as innovations. And I think when you package something as innovative, you remarkably silence all other questions. So if I present these contracts, or even a single one to an audience, as this new innovation that's going to save species, everyone wants to know how quickly we can save species, how transferable it is, how effective, what great examples I have of species being saved. And I think that this innovative potential question and the effectiveness question then tends to dominate the debate. And I think the legal aspects of these agreements, the problems of how they transfer norms between systems, what we might call technical questions of contract law, get lost in this search for innovation. So my first explanation for the gaps in our knowledge comes about because of this sort of blinding appeal of finding innovative solutions, particularly to global environmental problems. My second explanation for the gaps of our knowledge trace back to the problem of privity of contract. Contracts are private documents. They can make it to the public domain, particularly when the parties involved want to get some great press. But often what makes it to the public domain is a press announcement of the contract that was concluded. You don't get to see the text. And I think what has been missing to date in our analysis of these agreements is any textual analysis of the agreements themselves. And this can be explained by the fact that it's very hard to actually get your hands on these agreements. And to undertake this sort of close textual reading, you need to see what's in the contract. So this remains a major research challenge, but also a reason for the gaps in our knowledge. And I'll give you an example. The papers were dominated last year by the announcement of the Canadian Boreal Forest Agreement. We read that an area of Canadian forest larger than the size of Germany was going to be protected through the Canadian Boreal Forest Agreement signed between a number of American and Canadian, yes, radical environmentalists and other affected forestry companies. But I tried as I might for weeks, and when I gave up, I put my clever research assistants on the task. There was no way you could actually read the text of the agreement. So I think there's this disconnect between getting excited about agreements and then the frustration that happens because we don't actually get to read what they say. And it's probably a frustration peculiar to lawyers that you actually want to read what the agreement says. The third reason I would cite for gaps in our knowledge around these agreements is that they really operate outside the realms of either domestic or international law. And I think we are very much in the legal academy still trapped in the dichotomies that shape our curriculum and that shape our study of law. And so these agreements really break down all those dichotomies that are so fundamental to the way we organize law. They are both public and private. They are both state and non-state. They are both formal agreements and informal. They are both hard law and soft law. They're both local and international. They're both law and arguably non-law. And so we're not left with much if we want to hold dear the conceptual dichotomies that are important to our field. I think what results is a very technocratic approach to law when we do study them. And I think there's a real danger here because these contracts, as I've studied their emergence and their dissemination across different areas of the world, have very much followed a pattern where conservation organizations look where they have the local contacts to get the agreement signed. Once the first agreement's signed, it's shopped around to various different communities, to various different conservation biology hotspots, to various areas that have habitat in need for protection. And they move as though the contract is this form that has no connection to the culture in which it emerged. In other words, this shopping around of the standard form of biodiversity protection contract happens in the same way as a standard form sales contract might get shopped around the world. But it brings with it faulty assumptions. Assumptions that every system of the world is as eager to adopt this approach to market liberalism as the American NGOs who have created these contracts. It brings a faulty assumption, in other words, that contracts are not embedded somehow in the Anglo-American tradition in which they've emerged. So these contracts are taken to local communities in Papua New Guinea with the assumption that those parties respect the sanctity of contract in the way that Anglo-American business people would. It's an assumption that the written contract has a rarefied form. I mean, you can imagine a lot of the elements of contract that are culturally specific. And a really interesting way to get at this is through interviews. You can ask people who've signed, for example, carbon contracts about what their understanding of the contract is. And I've been told things like, well, there was this really nice group that came. I think they were either part of a development organization or something to do with the church. And they wanted to give us some money. And in return for giving us money, you know, we committed to take care of the forest. But, you know, that's not hardship. We do that anyway. So I think, you know, this reflected to the situation of a particular commercial entity entering into a commercial arrangement. But you can see how people have different understandings of contract and the purposes and commitments under contract. So when I look on the web now and I can understand the eagerness to come up with standard form contracts to protect communities in these negotiations, there's a group called the Katoomba Group that has now put up on the website model forest carbon agreements, model watershed agreements, and they're fascinating, especially when you see the degree to which Anglo-American traditions are deeply embedded in them. For example, dispute resolution clauses that exactly mimic what you'd see in an American commercial contract. So those are some of the sort of uncertainties for me around an approach to contracts that sees contracts as universal when they clearly aren't. In universities, we have a huge appetite at the moment, and probably over the last few decades, for interdisciplinary engagement. And where I see greater understanding coming in the study of transnational conservation contracts is from intradisciplinary engagement. In other words, more time spent talking between those of us who study law, but study different areas of law. And here I see a really important engagement between the field of contract law, which isn't a field I know that much about or teach, and the field of international environmental law, which is a field I know a bit better. So I think there's a lot to learn from contract law here about the way contracts govern relations, but also the way they are governed by the wider systems of domestic and transnational law. I think private law has a lot to teach those drafting and negotiating these agreements. I think starting from a framework of admission that the text of these agreements is important, is a very modest step. But I think that because so much of the literature around conservation comes from journals like Nature and Science, where it's written by scientists, conservationists, and certainly by economists who don't read the agreements or don't attempt to get the text because that's sort of outside the frameworks of their disciplines, there is much missing because a textual analysis hasn't really happened to date. But I think there's a danger of framing this uniquely within contract because I think we still have assumptions that private law is not political. It's easy when we talk about international law to point to the power disparities, to point to the unequal bargaining power, but when we talk about private law, we often take a much more depoliticized approach. And so here I think it's useful combining this contract law analysis with a more engaged international perspective that international environmental law can give. And I think by drawing in international environmental law, a lot of other interesting questions emerge, such as why, in terms of an international tool for biodiversity protection, are we placing our faith in a handful, and it's really 3 major global conservation organizations that are negotiating the majority of these agreements. Why do they get to choose the conservation priorities of the world? Why is it that American foundation money is going to be the major tool in determining, is it Latin America or is it West Africa in which biodiversity protection is going to succeed in these ways? There's a danger in this approach where you're essentially allowing people to bid and pay for habitat protection when the price is right. And it also has, of course, geographic inequalities that I think international environmental law would highlight. This approach of bargaining or buying nature conservation works with other countries that accept the approach. But are we going to see, a lot of these agreements concluded with North Korea, with Iran? These are not approaches that are likely going to protect habitat in countries that take markedly different political approaches to democratic countries. So I think there's some challenges from international environmental law about the unevenness of market approaches to environmental protection. Now, the last thing I want to talk about is what I see as the very instrumentalist perspective of environmental law that emerges from these instruments. And in turning to my last slide, this becomes quite a moment of sort of critical reflection for me as a scholar who's worked in the environmental area for a while. I think when you're an environmental law practitioner or scholar, you're really pushed to produce useful, policy-relevant work. There's a compulsion that environmental scholars have to pave the way to reform, particularly when you deal with these critical issues such as the loss of global biodiversity. There's an urging you feel to produce work that's useful. In other words, to say that I have found something really great, if we apply it in other contexts, we can really achieve something. And I think it's important to acknowledge this compulsion towards finding innovation, towards finding best examples, to finding successes, because it certainly shapes and can color the effectiveness of the research we produce. And so this is my sort of navel-gazing moment where I look critically at the sort of work I do and think, well, am I presenting an accurate story? When you are asked by a community to come in and show them an effective example of a forest carbon agreement, or an independent environmental oversight agency, or a model environmental assessment piece of legislation, there's always this temptation to find the best examples. And this sort of case study selectivity, I think, means that we don't always accurately portray the middle ground, the uninteresting examples. It's much less interesting for you if I say, there are all these agreements, none of them seem very much to have worked. Maybe some of them worked a little bit. That's just doesn't generate the excitement and interest of saying, I have this great tool, I'm going to save the world, I can protect all these species, I can save this habitat, and you can pay for me to fly business class around the world as I implement my contract throughout global biodiversity hotspots, which luckily are also very nice places to visit. So what I'm trying to do here is to be a bit critical about what I see as our overplay of success stories and our underplay of failures when we do research like this that is so context specific, when we look at specific contracts. I think there's a lot of different ways that law can look at these contracts. Certainly one way is this represents the new purchasing power of a transnational elite eager to offset environmental damage when the price is right. But I think that's just one version of the conversation. I think law still has a lot more that it could say about these agreements. And I'll end there. I'm very happy to take any questions or comments or reflections. Yeah.
Hi, I'm Jane Churchill. Just a quick question and comment. It's fascinating because I come from an intellectual property background, and what I hear in environmental law and lawyers going through is what intellectual property lawyers did in the early 90s when some of the trade barriers went down with certain countries, with the, the destruction of the Berlin Wall, getting into Russia, China. Again, some of the similar things, having to work with communities, as you said, that do not see things the same way as perhaps the Commonwealth countries do, and working with them. And I wondered if you had looked at some of the struggles that intellectual property law had and still goes through in trying to get into and construct enforceable contracts in countries that may not necessarily understand what the North American, what the British rule of law is like.
Yeah, I think that's a terrific example. It's one that I hadn't really focused on, and I will now. Certainly access and benefit sharing agreements, and that sort of side of intellectual property protection I thought about. But I think, maybe because intellectual property protection came with the appeal of protecting rights and making money, it went faster. And so I think you're right that environmental law probably has much to learn, and contract negotiators have much to learn from this experience of transporting model contracts around to different communities. So thanks for that. That's a really useful example. And I think in speaking more broadly about these contracts, I've only spoken about a very small example of one type of contract within environmental law. In other areas of environmental law, for example, around pollution agreements, polluters are negotiating regulatory arrangements that can be termed as contracts with regulators in different settings. There are carbon contracts that are, again, being deal-specific bargains. So I think that in each field, if we look at the contractual lens, we can probably learn a lot from your comments and see what's happened. Yeah, John?
Natasha, thank you very much for this very interesting presentation. I'm going to love your slides, by the way. You mentioned, I think Jane mentioned also this idea of perhaps not everybody has the same respect or regard or understanding of Anglo-American law. But then I thought, well, one of the principles of Anglo-American law that some people espouse is the theory of efficient breach. Okay, contract law being that contracts are less subject of a matter of honor as something that you can breach if the benefit to you is greater than the cost of breaching, and then you just pay damages, right? And I wonder about how that could play out in these sorts of scenarios.
Yeah, I think that's a great example because when I interviewed the negotiators of these contracts within the conservation agreements, I was very interested in the question of breach because it seemed to me that they were setting themselves up for breach. And that breach to me equaled failure of the agreement. And these organizations took very different perspectives on whether breach of the contract equaled failure. One of the first groups to go and negotiate the contracts thought that breach was fine. If they gave a community, $3 million to protect a watershed and not allow, some of the traditional uses that might be harmful to that watershed or what the conservation organization decided was harmful to the watershed, the community could take the $3 million and keep on business as usual, not change practice at all, which arguably would be breach of the contract and would be bothersome to us as Anglican American contract lawyers. And that group said, no, doesn't matter what they do. We just want to get the money into the community and hope that some good comes out. Whether any of the terms of the contract are lived up to is irrelevant to us. And so that was their approach to negotiating contracts. So when the next organization came around with a very different idea of breach, it came up with mechanisms in the contract about how the next payment of money wouldn't come if there was breach of the initial terms. The community said, yeah, more of those guys coming from Washington, D.C., with their approach to taking contracts seriously. And they said, but we know how the other group, what their intention was. And so the same approach of breach was followed. And that contract, the group started pulling back its funds, saying, we're not giving you the next installment because you breached the first. So they found it very hard that they weren't the first to set the culture around these contracts. But I think breach and its cultural determinants, is a fascinating area to look at more. So thanks. Yeah. Did you hand it again? Yeah.
Well, I think it answered some of my questions, but then you mentioned there's a lack of transparency in terms of looking at a contract and what's in it. So could there be some contracts that with the actual first of all, like how it works in terms of length? Like, is it 5 years of conservation, 30 years of conservation indefinitely, or and in terms of like some kind of a stake that the buyers would have. I mean, not the buyers, but then with the conservation is what kind of let's say power they would have over the over the land, over the conservatory land.
Yeah, so that's a series of good questions. The first, transparency, I think, is absolutely vital. And for those of you who are lucky enough to have Professor Odemusu teach you in foreign investment law, I think there's some really instrumental and instructive examples in international investment law where there has been a push for greater transparency of contracts, because as you can imagine, that is a field where much is determined by contract. And so organizations such as NGOs have played a vital role in setting up mechanisms for greater transparency of contracts. And I think that those sort of examples could be brought over to this sphere. Length really varies. I'd say 5 to 30 years is probably the norm. In terms of the legal protection that these organizations get, often say in a concession agreement, they get some form of lease over the land. Again, there's a real tension between around enforcement. These conservation organizations are in this for the sort of end game. They want to save and protect the territory and protect species, rather than necessarily enforce their rights against a national government or against a local community. So they don't really have the same interest in enforcing contractual terms that perhaps another contracting party would have if it was buying the forest concession to cut down the trees. And this is also pretty new. So we don't have sort of an empirical track record to say, here are examples where there have been, where law has been used as a mechanism for enforcement. And I guess anecdotally I could add that in my discussions with the people making these deals, they're not lawyers. So when I asked about things like breach and enforcement and remedies, that was a foreign language. It wasn't something they were thinking about. They were thinking about, okay, how long do we have before the painted turtle disappears? So it really did seem to be a bit of a foreign language that I was introducing in even asking those questions. Yeah, Patricia.
I just wonder what the motivation is for the privacy clauses. I could see with investment and other things, but I'm wondering why, once you've identified who the negotiators are, why they just won't make a cut.
I think it's probably similar to contracts that are negotiated here, like impact and benefit agreements. You don't really want the terms of your agreement getting out, because as the party putting money in, you don't want to be held to that price in your next negotiation. You want to try to get away with paying less. And as a community, you're similarly concerned about it getting out that you only held them, that you agreed to that price, because in your subsequent negotiation, you'll get less. I think also part of the reason these contracts are private is that it just becomes like any other standard form contract, that the term of confidentiality is in there. And even if they weren't private, as in confidential per the terms of the contract, you can see the sort of research challenges of getting your hands on them because there's no repository, and certainly no physical or online way in which you can search these agreements and get your hands on them. Yeah.
All right, just first off, thanks again for coming out and speaking. I was wondering, I mean, as someone who works in the